this session is about matrimonial property rights in Pakistan. I am Sulema Jahangir. I am the moderator for this session. Our esteemed panelists today are Ms. Reem Alsalem, who is the UN Special Rapporteur for Violence Against Women. We have Dr. Muhammad Khalid Masud, who is a religious scholar and an ad hoc judge of the Shariat Appellate Bench, Supreme Court of Pakistan. We have Ms. Sofia Calltorp, who is Sweden's ambassador for gender equality. We have Malavika Rajkotia, who is an author and family and property lawyer from India. We have Ms. Maliha, who is an associate director at Legal Aid Society from Karachi. And we have Mr. Mashood, who is a senior associate at AGHS Legal Aid Cell, which is the host for this conference. Thank you. So I will start today's session by saying that in Pakistan, we have often prided ourselves that we have an extremely good family system. And a few years ago, our former Prime Minister Imran Khan said, he said, there is a rising divorce rate in Pakistan, but our family system is so good, and this is very alarming. And that is because of the influence of foreign media that we have a rising divorce rate. And of course, you know, we as Pakistanis, we usually pride ourselves on our traditional family values and respect that we have for the sanctity of marriage. So what is the divorce rate actually in Pakistan? The figures that I could find was that the divorce rate in Pakistan is quite low, one of the lowest. It is about 0.57% of people who are married who are divorced, which is quite low. So I tried to compare it with India. And in India, I saw that the divorce rate is about 1.1%, which is, again, quite low. And in both Pakistan and India, what we have is that we have very low participation of women in the labor force, some of the lowest in the world. When I looked at the United Kingdom to compare it, the divorce rate is about 42% of married couples, which is, of course, a big jump from what we have in South Asia. Now, of course, our elected leaders or our other political leaders and various others, our clergy and our judges, they are all very concerned, why is the divorce rate going up? And they have blamed several factors on it, such as influence of foreign media, Bollywood films, Hollywood films, maybe even wedding dances, etc., etc. I mean, my concern is actually not that why is the divorce rate going up. My concern is why is it so low? It should be higher. Because if you look at it, and why is it so low? The reason it's low is because Pakistan, every second woman in Pakistan is actually classed to be illiterate. And it's more so in Balochistan, more so in Sindh, in KPK than in Punjab, more so in rural areas. And so that is why I think the low participation in the labor force, as well as the low education of women, I think that is why the divorce rate is so low. And the reason it's going up is because there are more and more women entering the labor force. There are more and more women and girls going to school now who are unwilling to put up with abusive marriages. And I think the topic for today is a very important topic because it affects half our population. So if 68% of women in Pakistan are married, that is a lot of people. And it impacts all these married women that when they have to leave their marriages, why don't they leave marriages? Why do we have a huge number of violence in domestic violence cases, but why do these women stick in these marriages, and why do we have such a low divorce rate? And that is because, as we will see through this session, that we have no matrimonial property rights in Pakistan. Women get very little inheritance, if at all. And during the marriage, if a woman has to leave a marriage, let's say after 30, 40 years, even after 5 years or whatever, she leaves with basically nothing. So she comes with whatever, and she leaves literally, you can pack her in 2 bags and say goodbye. She loses access to her children because she's unable to financially support them. And therefore, I think that is the reason really why we have such a low divorce rate. So we're going to start by discussing the social elements of this problem and how it impacts 68% of the women in this country. And I'll start with Maliha, who's worked a lot in this area, and she's a lawyer. And I will ask her, why does she think that how is this problem in Pakistan, how is it impacting women? And why are there no matrimonial property rights in Pakistan? Whereas in other Muslim countries, we do have them, but why not to some extent, but why not in Pakistan?
Thank you so much, Sulema. I think you raised several interesting points, जिसमें मैं highlight करना चाहती हूँ. Legal Aid Society मेरी organization, वकील बनते हुए मेरे पास बहुत cases आते हैं. Majority of women, whether for legal redress, कि court में जाना है या whether for advice. The majority of women have come to me for questions about my husband beats me, my husband is emotionally violent, is psychologically violent. मेरे options क्या हैं? What can I do? Where can I go? How can I protect myself and my children? Now this is not a class issue, I want to emphasize. ये होता है कि जो बिल्कुल unpad, poverty stricken, below the poverty line, to the most elite, high earning landlords, politicians, it makes no difference. The question is always the same. What are my options? और sadly options उनके बहुत कम होते हैं. Now उनका option ये होता है या तो अगर उनकी खुद families are willing to support them, by which means their father or their mother, their brothers, because in a Pakistani society, we are brought up generation after generation that the man is the earning member of the family and provides for the family financially. Now, हमारा एक social construct बन गया है because of this education, as we all know, women's education or girls' education is not emphasized. Employment is not emphasized, खास तौर पर घर के बाहर जाना. We all have a social शर्म का या ये issue है. A girl is geared or brought up to be a housewife. And then we have very few employment opportunities. Now, I myself, and I remember going for an interview to, in a very, very brief, dark phase of my life, I applied for a job for a corporate company. And I went for the interview, and the man asked me, at that point I was engaged, he said, but you're going to get married soon, and you'll have children soon. I said, yes, so? And he said, well, you know, how can we invest in you then if that is going to happen? Because you'll probably stop working. Anyways, luckily my activist roots came up. So फिर मैंने उसको सुनाई. I said, gave him a whole gender lecture, ended up lecturing him. Obviously, I didn't get the job for many reasons. But the fact is that if at that level, in a corporate world, which had, by the way, it had childcare, it had matrimonial rights, it had all of these rights, I would not have gotten the job based on that. There's very little hope for many other organizations, particularly जब हम domestic laborers, day laborers, factory workers की जब हम बात करते हैं, home-based workers. So the reality is employment is not an option. It's not encouraged either. The fact that the majority of places do not have childcare rooms, they do not have matrimonial property and safeguards in place, we do not necessarily have very active daycares, emphasis is that the woman looks after the child. So when she enters into a marriage, she brings with her the dowry, whatever the gifts that are given. Now we have law, the 1976 Act, which restricts the amount of dowry. Whether that is followed or not is a separate matter. But dowry is not usually assets in her name. Dowry is things she brings into the family. A washing machine, a cupboard, the bed, some assets, aage piche. But it's usually for the marriage. दूसरा उसको मिलता है, and this is all falls partially under what we define as matrimonial property, haq meher, her dower, which is the gift that the man gives to the woman at the time of a Muslim marriage. Now, under Muslim marriage, a marriage is considered a contract, a nikah nama. It's not romantic, it's practical. A marries B, and in consideration of that, a haq meher is given. Now, haq meher can be anything. It can be anything. It can be millions to property, to a house, to 52 rupees, to a wish. Now, practice, social practice has made many, many people, jo aadhe nikah nama, I think the first thing that when I advise people is look at the nikah nama and put your rights in that. They put in what did the Prophet give at the time of his daughter's marriage. But what the value of that then and the value of that now is very different. So they put in, I think it's 32 rupees? 32 rupees?
I remember my mother's was 32 rupees 50 paisas.
Oh, wow. Things changed since then.
Because people don't often want to do that at the time of a marriage. You don't want to think about a divorce. And the minimum amount is 32 rupees 50 paisas. And that's usually
I'll come to you after that. So it comes approximately to that. So there's a lot of pressure that comes in. Put it as low, don't talk about divorce. Nobody sees it as a protection element in the long run as well. So what happens is that this woman enters a marriage, not necessarily working, or if she's working after she has children, she has to look after house care because in many cases it's cheaper, it's safer to look after the children and the house, etc., etc. Marriage does not go as planned. he becomes violent, he becomes abusive. And even if not that, just simply they're unhappy. It doesn't always have to be violence and abuse. They're just not happy for whatever reason. So iske paas phir kya options hain? If she leaves him, what can she do? Now, if she has 1 or 2 children, or even herself, where does she go? How does she look after herself? The fact is, financially, women become vulnerable. Now, under Islam, when we talk about that, and I will not dare talk about Islam in front of Dr. Khalid Masud, I will leave that all to Dr. Saab to speak about. But briefly, speaking about, just very, very briefly, very superficially talking about it, Islam allows women to own property. Islam allows under marriage for a woman to have certain rights. Islam allows women to gain property, even have a share in property in a family and a marriage. Why does it not happen? And that all comes down to culture and society, and social construction and interpretation. Now, Ans is going to be talking a lot about the law and the interpretations the courts have given, but the reality is women do work in the house and a family. They contribute. It's unpaid work. Looking after the house, looking after the children, making sure the man has the ability to go out, not spend additional money, and to be able to do his work, that is all considered unpaid domestic work, which is not necessarily tabulated in money. So whether it's keeping after the house, whether keeping up with the family relations, all of that is considered unpaid work. And it's increasingly, hum baar baat kar rahe hain, ki this has to be recognized as her contribution to a marriage, even if it does not bring in financial input into the family, but it saves financial input into the family. So all of that is something that we need to start talking about a little bit more. Now, when we talk about matrimonial property, Pakistan mein and Khaltorp par the cases that we're kind of doing is we talk about matrimonial property as share in the immovable property, for example, the house, the car, land, agriculture, etc. But we also talk about maintenance. Now, every woman has a right to maintenance in a marriage. Whether her maintenance is given or not, the economic power that a man has over the woman, whether he chooses and how much maintenance to give her. The dowry, jaise maine abhi baat ki hai, jo bridal, the property she brings in with her, dower, the haq meher, and any bridal gifts that come in at the time of marriage. Now, all of these fall under the larger umbrella of matrimonial property, and the majority of times, the cases jo hamare paas aate hain, it's because maintenance isn't there. Bachon ke liye or for the wife. Now, which is also recognized as a form of domestic violence, of economic abuse as well. So what happens is that under Pakistani law, we have 2 types of laws. We have codified law, jisme hamare Pakistan Penal Code, Code of Criminal Procedure. In family law, we have Muslim Family Acts, we have the Hindu Marriage Act, we have the Guardians and Wards Act, Family Courts Act. We have all of these codified, which tells us jo hamare haq hai, hamare rights hai, processes hai, how do you actually deal with these kind of situations. But then side by side, for Muslims, we have uncodified Muslim law. There is a principle in courts which says that you can follow Muslim or Muhammadan jurisprudence. Now, Muhammadan jurisprudence is very wide, spans over centuries and centuries, and it comes to the question of whose interpretation do you listen to and whose interpretation are you following? Because interpretations have changed. Agar aap 14th century ki ya 20th century ki interpretations padhe, usme obviously differences to aa gaya hai. To take it away from controversial things, interpretations have allowed the Quran and Hadith said that you should not drink, which was interpreted later to include drugs and other kinds of, drug enhancement or, things that take you out of your mind temporarily. These are all forms of interpretations. But the interpretation is left to the judge at that point, or to the legislation at that point. And the question which we will be discussing today is what are the alternative interpretations which we in Pakistan are not allowed or have not been allowed to think about and allowed to discuss. And I congratulate this conference for actually bringing it to the forefront for the first time, that what are the alternative Islamic interpretations which we are not known, which are not known to us in Pakistan. So I think it's very important that when we, just to link it up at the end to summarize, is that women's vulnerability in Pakistan, in financial vulnerability, is because of our socialization and a social construct where education, employment, transport, concepts of shame and honor do not allow women to become financially independent. We are completely reliant on the men in our family who are considered head of the family, which in 2022, when I went for my CNIC application day before and almost had a breakdown because it said, who is the head of your household? And they didn't let me put my name down. It's just, anyways, sorry, that's a tangent. But the fact is, socially, the head of the household is the male. We are dependent on the men in our family for decision making, control over assets, and majority of the time when property is bought of any kind, it is usually under the husband's name. Because additionally, social contracts, Khaltorp, do not necessarily allow women to get CNICs, do not allow them to have bank accounts, do not allow them to have any kind of documentary which will allow them to purchase or own property in their name as well. तो कहते नहीं बेहतर है कि मर्द के नाम में ही कर लें, आसानी होगी, आसानी होगी. And it's a fact that even many upper elite class women whose husbands, when they buy property, they'll be like, nay, you know, it's too complicated. You don't have a history here. You don't have good record for property, so it's better we keep it in the husband's name. Now, if that goes bad or south, what's going to come to her at the end of it all? Because at that point, you're thinking all is fair. Women do the majority of unpaid domestic work, keeping up relationships, household, etc., but they do not get recognized or paid for it. Even though, as I'm sure Dr. Masud will talk about, Islam says a different thing about how much she should be paid for that. Women remain relevant to maintenance for the husband or for the father or any other member of the family, and when they have children, obviously that financial burden grows and grows and grows. The majority of cases, and which comes to the question about why is divorce rate so low, is because women cannot afford to get divorced. Not because they can't afford lawyers, but they can't afford to eat. They can't afford to live if they get divorced. हमारे पास जब ख़वातीन आती हैं, it is for how do I get my husband to give me money so I can feed my children, send them to school, clothe myself, and have shelter. Now, situations such as the floods have only exacerbated situations. Abhi bhi anecdotal reports have started reporting things about sale of children, wives being thrown out, wives being left behind. What rights do they have? When, and especially now the question comes, okay, household, livelihood, all of that. Now, if it's going to be redone, whose name is it going to be in? Who's going to have control over that? So there's just so much to discuss. I'll stop over here to let Ans and Dr. Khalid Masud talk about more of the legal and financial things. But the fact is, we do have space to allow for matrimonial property because we have the rights. The Constitution gives you the right. Article 25 talks about equality. We have right to protection of marriage, right to property. We have the law which says Islamic principles, which as Dr. Khalid Masud will talk about, will weave into recognizing women's rights to property. And I think this is the time we have to recognize that women not only should, but deserve to get that protection of their share in matrimonial property.
Thank you, Maliha. Thank you very much for explaining the social context of it. And of course the religious context. And as you say, the Constitution does allow us. I mean, in the Constitution it says that nothing repugnant to Islam can, you know, be legislated. And but I mean, what we're seeing is that there are many Muslim countries, Tunisia, Malaysia, Singapore, you know, which all follow sort of, I mean, I won't say Muslim countries because you don't say Christian countries. I'll say, let's say, countries which follow Muslim rules in family law. They allow, they are, you know, sort of much more generous towards giving women matrimonial property rights than Pakistan. Pakistan is probably one of the worst. So they have done it while still having, you know, justifying it through Islamic principles and saying, in fact, we don't have to justify it. That is what Islamic principles say. And they point to particular Islamic principles like Mata and others when they talk about that. So we will, I wanted to first go back and say what is the current status of the law in Pakistan, and sort of I think Mr. Ans Mashood will sort of elaborate that what actually, if I am sort of a woman, I've a 30-year marriage has ended, I don't have anything, like most women in Pakistan, I would say. You know, I just brought my dowry, I have a 30-year-old fridge or maybe a microwave I can get back. I don't think that's worth much now. I mean, what if I go to the courts and say, well, marriage is ended, I've got nothing, my parents have died, I can't go back to their house, my brother doesn't have any space for me, the old 30-year-old fridge is not going to do much for me. What can I get through the courts in Pakistan?
Assalamu alaikum. My name is Ans Masud. I work at AGHS, mostly as a family law lawyer and constitutional law at the cases. I deal with constitutional law cases at the high courts. So, Miss, in response to your question, the Muslim Family Courts Act, Section 5 provides a list in a schedule on the issues which can be raised before a family court. The list was recently amended, and several matrimonial property issues which the umbrella term matrimonial property includes, such as dower, dowry, and a broad term which allows for any issues that emanate from the nikah nama itself. All of those issues can be raised before a family court. But strictly speaking, matrimonial property, the legal distinction of matrimonial property is division of property which basically belongs to the husband at the time of marriage, and due to the non-economic contribution of the wife, the time spent by the wife who has raised children, who was a homemaker, who enabled the husband or enabled her husband to go out there and earn a livelihood and create a fortune, does the wife at the time of divorce get a share in that property? That is the strictly legal matrimonial property term, which is not recognized in Pakistan at the present state of affairs. But we do have an argument which is tenable under the law. Although it has not been applied in any legal precedent or a case, it has been discussed in several law commission reports. There have been several objections against it, against the continuing alimony after divorce. But one-time payment of distribution of assets and division and calculation of the share of the wife, that is something that has not yet been raised in the legal jurisprudence of Pakistan. The closest we've had recently is the case of Tuharat Firdaus versus Imtiaz Khan. This case concerned the the gifts that the husband had given the wife. In that case, the wife did not own any of the properties. In fact, she came from a very impoverished background. And at the time of marriage, the husband gave her gold ornaments. He gave her a house specifically. Normally, gifts belong to the wife unless she is the one who seeks a khula and she is the one who basically dissolutes the marriage. So in this case, it's a very interesting argument was made by the High Court. The High Court emphasized that the wife was allowed to retain the house in her own possession and ownership because she had spent a considerable time period and contributed to the marriage in non-economic, non-financial ways. This is the same argument that was initially used by the common law Western states, mostly the UK and even in the US, in which matrimonial property was distinguished for the first time as a right of the wife at the time of divorce. So we're already more than halfway there. We've already made that argument in our courts that when a woman is going to be a homemaker, when she contributes to the marriage, she raises the kids, she spends a considerable time period in the marriage, that is something that can be compensated in financial terms. So the only distinction step forward from this is whether this can translate into an actual remuneration of the marital assets. And in order to do that, the first thing that in order to complete the argument and possibly one day make a case before one of the courts is to see if there is any prohibition against that under any of our laws. Under Islamic law, there is no specific prohibition. Even if something is not specifically provided, I think Dr. Khalid Masud would explain better that there is, in fact, a better argument that at the time of divorce, a one-time gift should be made to the wife, which should compensate for her non-economic contribution. But even if there is no provision, the Supreme Court of Pakistan has held in Akhtar Qureshi versus Nassar that unless something is specifically prohibited in Islam, then there should not be any bar on the basis of Islam just because of unconventionality. So if something is prohibited in a custom or in a practice, that has no legal bearing. So if a special law, if a special judgment for that sense, or if an extraneous argument is made by one of our courts, which they've already made to some extent, and they only need to take that one step further, then there's nothing barring under the law which would prevent them. In fact, I'd like to emphasize that the CEDAW Convention, which Pakistan has ratified, the CEDAW Convention has under Article 15 and 16 specifically provided for non-discrimination at the time of dissolution of marriage. And the general recommendation number 21 of the CEDAW committee specifically talks about financial and non-financial benefits, and that they should be awarded at with the same weight. So right now in Pakistan, at the time of divorce, we only recognize financial benefits. We do not recognize non-financial benefits. Taharat Firdaus is the first argument in which a non-financial argument was made. But it was made on the basis of marital gifts. It was not based on the basis of the wealth that is a part of the marital home, which is accumulated during the time period when the marriage is subsisting. So I'd like to emphasize again, I'd like to revert to the Islamic context of this. The Federal Shariat Court has in the Suomoto case of 2006, in which it held that Section 10 of the Pakistan Citizenship Act is repugnant to the injunctions of Islam. The court held that Pakistan has, through its international obligations and Article 227, which is Islamic compliance, there's an Islamic obligation on Pakistan to comply with its international obligations. Those are not, they can't choose not to abide by any specific provision in any of the treaties which Pakistan has signed. So Islamic law, in fact, ordains, as held by the Federal Shariat Court, that any obligations that emanate from the international treaties which Pakistan has ratified, those are binding on our courts. So the general recommendation by the CEDAW committee on Article 15 and 16, and the CEDAW committee has, in fact, in the fifth periodic report of Pakistan, specifically called the state to provide non-economic benefit at the time of divorce. So the argument is, and the legal basis, in fact, is completely there, that matrimonial property is binding non-economic remuneration of a wife's contribution to a marriage is provided for in the law. But so far, there's never been a case specifically in which this progressive argument has been made. We only recognize gifts, maintenance, dowry. We have an evolved jurisprudence which permits our courts to adjudicate on these matters. But with respect to properties that a husband brings in and a wife non-economically contributes to, currently there is no provision in the law.
Yes, thank you, Ans. So, I mean, the point is that I think, to sum up, in Pakistan, you know, regardless of how long you're married, you do not have any access to the marital capital. So this was, well, in England, because I'm also a lawyer in England, so we have to also think, how is this going to happen? How will that change? It obviously puts half our population on the back foot, because, you know, we have low labor participation of women. Women don't get the same inheritance rights as men. In fact, they often get nothing. They only get their dowry. So why, you know, what can happen? Does this come through Parliament? Does this come through the courts? Now, I want to, I'm going to have Dr. Saab speaking after this, but I just wanted to ask him this question, that in England, 21 years ago, the House of Lords made a landmark decision in the case of White and White, in which they said that the property, marital property should be equally divided, and the yardstick is of equality. In that case, there was a long marriage of 30 years or so. The husband had done very well. He was, you know, working, set up a business, made lots of wealth. The wife was, you know, a homemaker, looked after the children. And upon a divorce, the husband said, well, I put all my money into this business, and I did this, and this was through my achievements. But the court said, well, no, she is the one who looked after the house, and you cannot discriminate against a woman because she has been doing something else. And believe me, in fact, when I was on maternity leave looking after a small baby and I went back to work, I thought it was so much easier. So I think she had by far the harder job. The court said, well, 50-50 is the yardstick of equality, and that is the way in England courts look at things. And where there are ample resources, where there are not ample resources, the way courts look at it is needs. So usually in a middle class or lower middle class family, the wife's needs are more because she's often not working, and the children, the custody of the children are given to her, so she gets to keep the marital home, and the husband is usually the one who has to move out. And of course, he has to pay spousal maintenance if the wife is not working until the time she is able to get back on her feet and find a job. So we've seen that in this case, the courts have actually stepped in, but Parliament has not stepped in so quickly in England by saying yardstick is of equality. Dr. Saab, this is what we've seen, the role of the courts, at least in the United Kingdom. Now, in terms of what is happening in other Muslim countries, because obviously in Pakistan there is a bigger debate than this session can have, which is that we have to remain within the Islamic principles. So, okay, fine. Let's look at the other countries which are following Islamic principles. In Malaysia, the court can order a division of matrimonial assets after assessing each party's contributions. And where a wife has not made financial contributions, she would still be entitled to a third share of the assets, depending on the length of marriage. In Singapore, Sharia courts have the discretion to take into account the wife's non-financial contributions to the marriage, and where a wife has made no financial contribution, she is usually still entitled to about 35% of the marital assets. In Turkey, revisions to the civil code stipulate that the equal division of property and assets acquired during the marriage is the default property regime. In Indonesia, women's non-financial contributions are recognized, and the court has the discretion to split the matrimonial property upon a divorce. Similarly, we have seen this in other countries such as Jordan, Libya, Morocco, Algeria, Egypt, Syria, Tunisia, where mata is paid to the wife in addition to dower and maintenance. In Pakistan, there is no concept of mata. Similarly, in many Middle Eastern countries, there is a strong tradition of adding conditions for financial maintenance and capital awards in the nikah nama, which we do not have in Pakistan, because as I said, most of the time it's a very nominal amount. So when they have that dower amount in the nikah nama, so we see that in our Muslim sisters in other countries have some protection, whereas in Pakistan we fall, we rely on basically nothing. So I will come to Dr. Saab now to tell us his viewpoint as a judge of the Federal Shariat Appellate Bench from the Supreme Court. Thank you.
Bismillahir Rahmanir Rahim. As you might have noticed, the Muslim law, and especially matrimonial property law, is so complicated, and also there are so many misconceptions or wrong conceptions or disputed matters. So I had prepared actually to make a detailed discussion analysis, and this I prepared as slides. Now, I don't think that I have time to go to that. I request the organizers and also anyone who wants a copy of that slides, they are welcome. Now, my problem is totally being confused, and I will share my confusions. First of all, the matrimonial property concept is a modern concept and is still being discussed and is still being developed. It's not clear. In Pakistan, usually matrimonial property, or with matrimonial property, people start to discuss maintenance, dower, and all these things. Matrimonial property is a new concept, and we cannot expect jurists in the 7th or even 17th century or 18th century could think of it. But important thing is, and I'm not saying as a defender or apologist, but that in Islam, in Islamic law, in the Quran, in Hadith, property right are the rights of women in marriage. Even rights of property were available and are available in Islamic law to the slaves. The slaves can buy their liberty, from their property, that the earnings or something that they have. It means that they have a right to property. Now, what we are missing in the modern concept is that the idea developed in European laws with a concept of women to have rights of property in marriage. Because until 18th century, until 1860 or 62, when this law was passed, when a woman married, her property automatically becomes husband's property. So that was the significant moment when this was clarified, that the property that belonged to women before marriage still will remain property rights for the woman. So what is matrimonial property. Matrimonial property is during the marriage, not before the marriage and not after the marriage, but during the marriage. And the concept was that whether wife is contributing to the decoration, to the maintenance of the house, or raising children, or this whole household, and she is not salaried, she is not given any money for that. So that means that this husband and wife have both contributed to this matrimonial property. It is not the single property, and it's not that the woman is getting from husband, but it's a matrimonial property during the marriage which both have contributed to create. And the term in the Islamic law, which is more applicable here, is they call it musha, undivided property. And that is the concept of matrimonial property in the medieval period and the fiqh period. Although this was, this is not a part in Pakistan, because in Pakistan, I will use some new language. In Pakistan, there are 3 laws. One is common law, and then common law developed into Anglo-Muhammadan law, which is a hybrid. And then we have what we call Islamic law. The term is modern. There was no Islamic law. It was fiqh. And fiqh means jurisprudence, jurist opinions. It was never a state law. It was not legislated. Islamic law as a concept, or we can say law in Islamic history, developed in 2 concepts. One was called fiqh, which means literally understanding, jurisprudence. And second was siyasa, which means the political, public law, political aspect. So these both were combined in the Islamic law, and the siyasa, or the public law, was legislated or created by the rulers or the state, if we can use the modern term state for that period. And that dealt with lots of other things, but practically those things which are not covered by fiqh. Now this claim that fiqh is comprehensive is only based on this concept. Then in fiqh you also have the ritual prayers, zakat and all that, and because these are not disputable in the court, the court has nothing to do. So that is why during the colonial period the term personal law was introduced, or the fiqh or the Sharia law were only limited to the personal matters. That included also the marital property and inheritance and all those. Now, with that explanation, I think matrimonial property, I may be wrong, but what I understand from the discussions, a matrimonial property is a new discussion, and it is going on in all Muslim countries. Some of the names have been already mentioned by Muniza. But Singapore Muslims, they have 50-50 already in law. In Morocco, Tunisia, it is closer to that. In Uganda, in Nigeria. Why? Because in Islamic jurisprudence, in Islamic law, there are 4 or 5 schools of law. Among them, the Shafi school and the Maliki school, they already accept the interpretation which is from the Quranic verse. And let me give you a little bit of example of that. The Quran in the Surah Al-Baqarah, there are 2 verses which says that as soon as marriage is announced, mata payment of mata, I will explain mata. Payment of mata becomes obligatory according to one verse and becomes commendable according to another verse. So those who say this is mandatory, this is the Shafi school, and those who say it's commendatory, this is the Maliki school. Now all these areas where very simply they went on to accept the new modern concept of matrimonial law, they belong to either Shafi school or to the Maliki school, and their interpretation is that of mata. Now, for Hanafis and Isna Asharis and Hanbalis, the other three schools, they interpreted mata in terms of maintenance, in terms of dower. Mata literally means property, but it has no, in the Quranic tafsir and all these discussions, it has no minimum or maximum definition. It's just a concept, and it's better to call it property, not gift, as most of the people who translated the verse in the Quran, they said it's a gift from the husband. It's not a gift, it's a mandatory, and I tell you that in 9 cases from the medieval period before the judges, as soon as divorce was announced, they, instead of discussing other things, they said, first you must pay part of your property. So that was the base. And just one anecdote. In one of the cases, the person who was, both husband and wife came to the court, and husband announced the divorce, that I don't agree what she's saying, I divorce her. The Qazi said, okay, now you are mandated, you are obliged to pay mata. How much mata you give? This person said that in the Quran, it says, haqqan lil muhsinin, those who are generous people, muhsinin. The Qazi said that the Quran also said that it is haqqan alal muttaqeen, those who are God-fearing. He said, I'm not God-fearing. He says, okay, you don't. But within 2 or 3 weeks, came back, and he said, well, you accepted, this is Pakistani case, similar to Pakistani cases, about 62. When he came back, the judge asked him, did you appear before me last time? He said, yes. I said, last time you accepted that you are not a God-fearing person. So I don't accept you as a witness in any case. So that is not clearly, but in the judgments in this early 8th century cases we have. So this was introduction. The possible reform in Pakistan, because so far Pakistan, all the writers or researchers who have written on this problem, they are not going to this mata or the matrimonial property. That's the problem that I said. That's a very complicated, and it's not possible to do it. So the crisis is actually, I call it crisis. Crisis is actually in the Constitution. The Constitution has brought 2 laws together without giving justice to the jurisprudence of both laws, common law and Islamic law. Fiqh law, as I said, is not a state law. Fiqh was based on 2 principles as far as property of women is concerned, patriarchy and gender inequality. For them, it was gender justice. So unless we revisit and reinterpret the property, the patriarchy and the gender equality, we cannot really reinterpret the fiqh or the Islamic law, because it's based on that. And secondly, the common law or the jurisprudence that we have, it is not, it is more based on precedents, and that's why I will end by saying that the way forward is through judicial ijtihad and going back to the understanding the Quran from the modern perspective, because the Quran does not say that if marriage is bilateral, the divorce should also be bilateral, not unilateral. I can go on, but these are the things. These are the things.
Because we have
that,
3 more speakers left and
yeah,
very
no,
little time.
I understand.
Thank you, Dr.
But-
Saab. Thank you so much. Thank you so much for your time and making us understand. And of course, your experience as a judge is very valuable here, because you are the one who is actually making all the decisions that change people's lives. We are advocating them, and you've got the real power in your hands. So thank you very much for your experience on this. Next speaker is Malavika Rajkotia. She is joining us virtually from India. She is one of the best known Indian family lawyers, and she's an author of a book called Intimacy Undone. It's about family laws in India, and I would highly recommend it to you. This is the last book I finished, and I thoroughly enjoyed it. Thank you, Malavika, for joining us from India. So we've had this discussion here in the panel, ending with a former judge here from the Shariat Appellate bench of the Supreme Court. And we were discussing that in Pakistan, Muslim women do not really have any matrimonial property rights, and of course the problems that it leads to, and we've looked at the viewpoints of the lawyers as well as the judge. In India, I wanted to discuss what are the matrimonial property rights for Muslim women in India who, and Islamic rules apply to them, I understand, and then Hindu women for India. I mean, we know that in 1985, the Congress government fell in India because of this issue of matrimonial property rights, because of the Shah Bano case, where a woman was asking for very bare amount of maintenance, and the Muslim community rose up and said, well, she should not be allowed it because our Muslim laws do not allow it. And the Congress government almost fell and had to make political, sort of deals at the last minute, and of course change the law at the woman's expense so that they could stay on in power. So I just thought that it would be great to get the Indian perspective from you. Thank you.
Right. So thank you for inviting me. Yes, so the position with regard to the case was actually for the personal laws for each, as you do marriage applying to the Hindus. We had a uniform regard to under the Criminal Procedure Code, which is Section 125. Now, that was an opportunity for any woman, regardless of her religion or religious identity, to access to for an urgent relief to take care of vagrancy and destitution. It was only for extreme positions. In that situation, Shah Bano, and in any case, this is important to note that the Supreme Court had been allowing and had upheld the application of the of Section 125 to women, including Muslim women, regardless of the fact that they had their separate personal law as well. Now, in that context, the Supreme Court basically upheld and said that 125 would apply. Now, the uproar, frankly, was more to do with the reaction, and may I say, it was certain observations that were made at that point with regard to the nature of the arguments that were made by the husband. And the nature of the arguments that were made by the husband, in fact, sounded very familiar to the story, to the account that Dr. Masud has mentioned about saying to the judge that is for the God-fearing Muslim, whereas I am not that. Implying there, because in court it was said that surely the Prophet also said that beyond that period, there is an amount that should be paid because what is in the interest, and that is fair, that is moral. And it was said Prophet had said, God-fearing Muslim, and here the husband of Shah Bano claimed that he was not.
I will move on to our next speaker, who is Ms. Reem Alsalem, who is the UN Special Rapporteur on Violence Against Women. Thank you very much for coming here. And I wanted to ask you about CEDAW, and I know my colleague Ans just mentioned it, that Pakistan is a signatory to the UN Convention CEDAW, and where it does say that women's contributions, financial and non-contribution to and non-financial contributions to a marriage must be recognized. And of course, we see that with the laws that we currently have in Pakistan, Pakistan does not comply with that. What possible encouragement, or I don't know how, persuasion can the international community do to help Pakistan realize the lacuna on the law here and what it can do to make it better? Thank you.
Thank you very much. First of all, I wanted to thank you really, and thank Nida for having me again this year and for facilitating also my participation in person. It's really a pleasure to be with all of you and to be in Pakistan and to share the stage with such an esteemed panel of speakers. I really feel I don't really have much left to say since it was very eloquently covered by my fellow speakers. I'm particularly happy to be in Pakistan, a country I used to come frequently to, because in another life I was based in Afghanistan for 2 years. So of course we would come frequently to Pakistan. I was also in Pakistan for the Mansehra for the earthquake, end of 2004, 2005. And perhaps this is a good sort of segue just to say that I would like to express my deep solidarity with the people and the government of Pakistan for this incredibly tragic calamity that has befallen the country, and that really demonstrates that the climate crisis is not theoretical. It's really the new normal, so to speak, that we are facing. I also want to, since I'm here, pay tribute to Ms. Asma Jahangir, whose legacy brings us together. I personally didn't know her, though of course many special rapporteurs did, since she was a special rapporteur, and her reputation precedes her. And of course, one cannot do justice to describing the impact that she had, which goes beyond Pakistan and really is worldwide. To answer your question, allow me maybe just to say that, of course, human rights standards are enshrined in customary law and human rights treaties. Many, actually, the wide majority of them, Pakistan is a member of, including the Convention on the Elimination of All Forms of Discrimination Against Women. And perhaps the reason that we hear so much reference to it is that it's really, first of all, one of the most widely ratified treaties, but it also really governs in so many ways the rights of women and the duty to protect them and the duty not to discriminate against them in all shapes or forms. So if I can say, it's almost like the Bible or the Quran of women's rights and gender equality. So CEDAW, really, the essence of CEDAW can be boiled down to the fact that it said no discrimination should happen against women and girls. They should be able to enjoy their rights, and in fact, discrimination is condemned in all its forms. And this principle is repeated, of course, in other key international human rights treaties, because, of course, there are others that say that all humans are entitled to social, economic, and political rights by virtue of being human. The Universal Declaration of Human Rights also says everybody is equal in law and in practice. And CEDAW takes this obligation further by saying, actually, that states have to really uphold this. They have to modify social and cultural patterns to eliminate also prejudices, customary, and all forms of practices that are based on the inferiority or superiority of either of the sexes, or that is based on the stereotypical roles of either men or women. So it requires the state actually to take an active role to prevent that and to address that in a comprehensive manner. And so Pakistan is obviously also a member, and as was said by my predecessors who spoke, there is no reservation by Pakistan to CEDAW other than a general statement that its obligations under CEDAW should not contravene its obligations under its constitution. Now, what this also means is that the state is not just obliged to do that sort of when it comes to its own relations with women, but it also has to make sure that this principle of non-discrimination is upheld also within the family. So, we cannot say, oh, this is a private sphere. Me as a state, I'm not responsible for it. No, actually, the state has a responsibility to make sure that also within family and family law, there is no discrimination. And the CEDAW committee, so the committee that sort of monitors how countries implement the convention, has actually regularly spoken about the issue of discriminatory property rights within marriage. And it has also emphasized on numerous occasions the importance of women earning an income, as well as the financial and non-financial contributions they make to marriage. So meaning also the non-monetized contributions, whether it's through childbearing, childcare, taking care of the elderly, taking care of the house, all these are responsibilities. And in fact, CEDAW went as far as having a general recommendation dedicated to this issue on equality in marriage and family relations. And this is General Recommendations 21. You may ask me, what is a General Recommendations? It's basically a guidance note on how to interpret the convention. So the committee saw that the issue of equality in marriage was sufficiently perhaps important, but also misunderstood or under-referenced, that it decided to dedicate a whole description or guidance note to states and other stakeholders on how to deal with that. And then there's also a general recommendation number 29, which is on the economic consequences of marriage, family relations, and their dissolutions. I should also say that the issue of matrimonial property and access of women to property is an issue that has come up also in the review of Pakistan's sort of respect for its own obligations under CEDAW. So, for example, in the 75th session of 2020, the CEDAW committee recommended that Pakistan ensures that family laws provide for financial protection for women upon divorce in the form of equal maintenance levels and equitable shares in matrimonial property. The last thing I would say that we as special rapporteurs, and including my mandate, we have not written specifically to the government on this issue, but we have written to other governments on this issue. So there is also jurisprudence in that regard. Perhaps if you allow me just to close, I will not dwell on the issue, on the issues of, the nexus between religion and human rights law. As we all know, human rights is inalienable, indivisible, and should be upheld, and it's an obligation. But it's also a journey, meaning that as long as there is a political commitment to move towards human rights, then of course it's understood that it is a process, so to speak. And here I want to just reference the Vienna Declaration of the Program of Action, which was adopted by consensus by states. And it says, on one hand, that states have a duty to promote and protect human rights irrespective of their economic, cultural systems or political systems. But it also says that the historical, cultural, and religious background of these countries should be taken into consideration while they do that. So that to me says that there is a recognition that it is a process. And I think Dr. Masud explained very well, actually, the confusion we see today between fiqh on one hand and sharia. and that fiqh has to, by its very nature, take into account the realities of today's society, and therefore the realities that existed when Muslim family law was codified are different now. The role of men and women and their contributions are also different. So a very strong argument can be and should be made that fiqh should evolve, since the original situation for which it was designed has changed. And Maliha also spoke to the fact that now also women work outside the house, contribute enormously also to the ability of the man to gain income and to make money, because she does work inside the house, that therefore allows him to go outside the house. So just to say that, therefore, I mean, the puzzle where religious norms, human rights, and constitutional guarantees do not have to sit in opposition to each other. They can actually complement each other. And as a final word, in addition to the examples that were given about the practice of Muslim majority countries, I think we can talk about, strangely perhaps these days, Iran, which has also a detailed system for recording what a woman contributes to family business and property after marriage, and that is taken into consideration when assigning the shares upon divorce. There's Kazakhstan also, which is another Muslim majority country, where the marital law provides that any property acquired during marriage is considered jointly owned by default. And finally, the Maldives, which says, despite the fact that they have made a reservation to Article 16 of the convention, the CEDAW Convention on Equality in Marriage, still courts in the Maldives divide the property equally when the marriage is registered as a joint partnership. And it acknowledges women's domestic work and childcare. So I think Pakistan has a lot of examples that it can follow. And in fact, what happens in the CEDAW committee is also, even those countries that have reservations under the justification of religious or customary law, there are discussions that happen about these reservations, right? And there are a lot of discussions that happen about, well, the intent and the steps that the state is taking in order to really move towards its obligation. So we have to keep that conversation alive. And I would say that it's important to have really as inclusive a discussion among legislators as possible, with the participation of religious experts, not only Muslim jurists, but Pakistan is also home to other non-Muslim minorities, so they also have to be included in this discussion. And I apologize for taking a long time. Thank you very much.
Thank you very much, Ms. Alsalem. Thank you for your contribution. We have another speaker now. Thank you very much for your contribution. I think time is ripe. We have some women legislators in particular, because I've written about this issue in the newspaper, who contacted me saying that we are ready to put in a private member's bill in Parliament. But I think there has to be some consent, some international push as well for Pakistan to sort of keep up to its international obligation. We heard from Dr. Khalid Masud here, who said that, you know, this is something that Muslim countries are doing. So hopefully in other areas where we have very, very bitter fights in Pakistan, this is one area where a lot of women can derive benefit, and it may not be such a bitter fight. So it's something to look forward to. And last but not least, we have Miss Sofia Calltorp, who is Sweden's ambassador for gender equality. And I want to thank her for her time in waiting for us, and for her time to be here with us virtually today. As we know that women around the world look up to Sweden for its feminist foreign policy. And of course, Sweden is sort of looked up by everyone to say, oh, look, gender equality is so much better in Sweden. And they say, well, it's not just the right thing to do, it's the smart thing to do. And then in Pakistan, of course, we have one of the worst, in terms of gender equality, we have some of the worst statistics in the world. And then, of course, it is linked to economic development. Women are not in the labor force. We have a lot of overpopulation. So it's obviously not the smart thing to do. So I would like to welcome her, and we will hear from her. Thank you very much.
Thank you for having me at this extremely interesting and important conference. It's a great honor. And of course, I would have liked to be with you in Pakistan, but that was not possible. I hope that will be another opportunity. I have listened very carefully to the panel and learned a lot about Pakistan, the matrimonial rights, and I think that this type of seminars and discussions are extremely important, of course, to advance women's rights and gender equality. Of course, each country has its own journey to make. In Sweden, we have over decades systematically worked to improve gender equality for the very reason that you outlined, that it's not only the right thing to do, but the smart thing to do. And our experience is that when we have included women in the formal workforce, we have recognized unpaid work, we have done tax reforms that have allowed women to gain access to resources and be part of society. That has meant a lot for the advancement of our country, both in social terms, but also in economic terms. So, of course, gender equality is a very broad concept. It's a holistic concept, and I do believe that each country has to look at the issues from their starting point. So I'm not to give any lectures, because I recognize also the challenges that you have in Pakistan, and as I said, this type of discussions are extremely welcome. The only thing I can say from an international perspective is that women's equal access to resources and the issue of matrimonial rights that's been discussed here today is, of course, an issue of equal access to resources, to make sure that women have resources to be part of society, to develop themselves, but also that women's role in society are recognized. We heard about the unpaid care work, about the burden that women bear in the households of Pakistan, and to have that recognized and make sure that women's right, equal access to rights, to resources is a key issue for gender equality, but also in terms of addressing the challenges and to achieve political and economic sustainable development. Of course, gender equality is an issue of discrimination. It's an issue of including half the world's population in our societies fully and to have their rights respected. But it's also a prerequisite. Gender equality is a prerequisite to address global challenges and to achieve results in terms of political and social and economic sustainable development. So the only thing that I can contribute to what has been an extremely interesting and rich experience for me is to say that Sweden, of course, stands ready to work with Pakistan, to the civil society of Pakistan, to all the actors that we've heard here today, to see how we can contribute and support and work together on an issue that, in our view, women's equal access to resources is key to achieve gender equality, which is of benefit not only for women, but for the societies as a whole. There are so much research that shows that societies that are gender equal are healthier, richer, and it benefits not only the women, but also men and everyone in those societies. So again, thank you for having me. Thank you for extremely interesting panel, and Sweden stands ready to work with actors in Pakistan on this issue. Thank you very much.
Thank you, Sofia. Thank you for being here and taking your time out for us. We have a very long journey ahead of us. But, you know, I mean, we look up to Sweden and we feel inspired by what other countries have achieved, and we are on our way in the journey. There are lots of women in Pakistan who continue to struggle and fight, and of course men as well. And I think this is one area of law that we can make a difference to. I just want to bring back our speaker, Ms. Rajkotia from India, please, because I think what is really important for us to see, because, you know, India and Pakistan were one country, we have similar laws, we have, you know, in India as well, we face similar sort of challenges, and it's very important to hear what is happening in India with this. So, I mean, could you please describe to us the laws for women, Muslim and Hindu women in India in terms of matrimonial property rights? Thank you.
So I'll do it very quickly. I think the important thing is just as an overview, in India, yes, we are making quantum leaps, I have to say. But on paper, there is the needs and wants, rights approach, yes. But even though it is there in theory, practically it does not translate into meaningful maintenance awards. But theoretically, yes, we have made great strides. But the most important development was in the Hindu law in 2005, which was the Hindu Succession Act was amended, under which a woman now is what is called a co-partner in the Hindu undivided family. Now that makes her on par with her brothers and her father. And she has a right by birth, which is inalienable. So to my mind, that is going to become a very important next step, because the question really which we are asking while we are doing these conversations is about dismantling patriarchal structures. Now, as my predecessor speaker had said, that it's about women's access to resources, which means equal opportunity to work and so on and so forth. But if it also becomes equal inheritance, and it's got nothing to do with marriage, then yes, it might even redefine the concept of marriage. Whereas the reluctance, which even in can you hear me? Hello? Can you hear me?
Yes, we can hear you. Yes, please.
So the reluctance, even during our legislative assembly debates when the Hindu Code Bill was being argued, was that we can't have women so equal because they won't want to get married. So in fact, that is recorded in Parliament as when you read those. So it is quite amusing because the patriarchal structure actually is asserted because it is men who need marriage more than women. I mean, we should actually recognize that as a starting point. So within that, the important development has been, having said which, the law is on the one hand, society and societal structures and custom continues to be traditional and sometimes and very often, too often, oppressively patriarchal. So we simultaneously are suffering the extreme backlash of how custody battles are fought, diminishing her in court, and all of those aspects as well. So in this very short time, what I want to say is right of privacy has now been recognized, and that includes women within a marriage. That goes a long way to enabling her. And our current Chief Justice Chandrachud has got a promising 2-year tenure in which he has openly said that he is a feminist. Now, whether that translates into judgments, only the next 2 years will show us.
Thank you very much for your insight on India. And we can see that India still is also quite a journey to go, a bit better than Pakistan. But of course, you know, we are sort of siblings, and we also have sibling rivalry. So sometimes we tell one judge in this country that the Indian court did that, and that's the best way to get a relief. So I think that...
Well, I used the Pakistan habeas corpus. I used the Pakistan judgment of return of a child, which has been quoted by our High Court. And we relied upon that because we had the same structure of the Indian Penal Code and the Criminal Procedure Code. So that was very useful to us as well.
Yes, I mean, that's why I say that I sometimes use your judgments when I want to convince a judge here. And if nothing else gets their growth, they say, oh, an Indian judge did that, then I must do that too. So somehow, all the jurisprudence and all the Islamic laws somehow bend in their favor, and they rely on very good interpretations. So I think, yes, while we take examples from other countries, an example from India is quite relevant for us. Malavika, do you have anything more to add, or can I end the session now?
I think we are short, you know, this is a big topic. I'm just very grateful that I was able to participate. There are lots of little bits that we could talk about, but for the moment, I'm very grateful with this connection for your patience in having heard me and patched me back in. Thank you.
Thank you, Malavika. Thank you very much for your contribution. And yes, sorry, we are running a bit late and on time because our previous session also ended a bit late. But I want to just end by asking all our panelists to maybe sum up in 1 minute what they think in terms of matrimonial rights. Do you think that this is, we can start with the special rapporteur, whether this is something that Pakistan can be sort of taken up on? Pakistan always relies upon sort of Islamic rules, etc. But, other Muslim majority countries have done it. I mean, I think maybe this is something that will give a lot of hope to a lot of women in Pakistan. And is that something that's possible?
One-word answer, yes.
Yeah, thank you. I like that word. Yes, because we usually hear, women always hear no in everywhere. So I think sometimes we can hear a yes. And Maliha, what do you think? Do you think that this is something that even judges are quite fed up of? Because I see High Court judges telling me, I feel embarrassed. This lady who's middle-aged or elderly lady, 30 years after a marriage, she comes to me asking me for maintenance. I can only give her 3 months maintenance. Her husband's packed her off with 2 suitcases and chucked her out of the house. She does, and she's looked after the kids. She spent 30 years of her life there. I feel bad. I want to do something. But what can I do? There is, the judge can't make up law. I mean, in some cases they can improvise, but it is for our parliament to come up with that law. What do you think, Maliha?
Thank you, Sulema. 2 things. One is that I just wanted to share, we have 2 policy papers on this subject. It's lying on the table over there, so everyone is welcome to take these as well, which helps make this case stronger. Just to summarize, the lived realities of women in Pakistan demonstrate the need for financial security for women, which comes through maintenance and especially matrimonial property and the access and share and equal share in resources made during marriage. So the lived realities tells you that it's necessary. The Constitution demands equality, which allows for the legal framework and arguments which support the need for equality in shares and matrimonial property. As Dr. Khalid Masud has also shared, and also the Islamic principle is what is not forbidden is permissible, allows the Islamic space for making such a law and for the judges, if they so wish to use their discretion, to allow for a share in matrimonial property. And lastly, even the international law supports this. So there's nothing which stands against it except our culture and society and patriarchy. So there's reasonably no argument against it. So the fact that it hasn't been done so is shocking to me, and we should no longer and cannot stay silent on this any longer.
And any input? I know that you have met with judges who have themselves said that I'm so sick and tired of this.
This reference of a 30-year-old marriage which was being dissolved, and then the High Court judge was speaking to both of us, and he was basically expressing his frustration on how there's nothing that's there in the law for him to do. But the thing is that we should follow suit from the Federal Shariat Court judgment of 2006, in which it was held that Islamic law ordains that international commitments, and especially CEDAW Convention, is binding on Pakistan. So the general recommendation number 21, which the UN Rapporteur also mentioned, I think that is binding on Pakistan at the present state of affairs. And the High Court judgment of 2019, I think that also specifically ordains that non-economic contributions of a wife need to be translated into matrimonial shares, and at the time of dissolution of marriage, those need to be equated and remunerated to the wife. So the framework is already there, and the only next step forward is for a particular precedent in this regard. Even if there is no legislation, I think the courts have ample jurisprudence and legal framework to act on it.
Thank you. And Dr. Khalid Masud, there were 3 Women Commission reports. In fact, one of them, my mother and Maliha's mother authored as well. Oh, sorry. And in that, all the reports unanimously said that this area is where legislation should come and women should be given at least mata, like with other Muslim countries. But we had Maulana Thanvi, who was then representing the clergy, and he was in fierce opposition he was also in fierce opposition that marriages and divorces should be registered. But he was in fierce opposition that women should not have any access to matrimonial property rights. What do you think? Do you think that this is something that is achievable?
The problem in Pakistan is that we have been doing reforms, not reconstruction, by which I mean that any amendment, any change should be backed by a new jurisprudence. Because unless we have that, the both common law and also the Islamic law, they have a history and they have based in patriarchy and gender inequality, and which was considered gender justice. So we have to go back to that discussion, because passing a legislation and then implementing it in the courts and acceptance by the people need a long discussion, long participation by the people.
Thank you to all the panelists. I hope you found this session useful. There is a lot of food for thought. I think Dr. Saab is right. We need to have a bigger discussion. We need to have more stakeholders involved. And of course, the international community has to play its part. But as I said, 68% of women over 10 years old in Pakistan are married. So it impacts rather a lot of people, tens of millions of people. And this is something that can be done, and we are hopeful that it will be done. Thank you very much for your participation.